Independence National Historical Park. I'm Patrick Suddeth, the Deputy Superintendent. It's wonderful to see such a great audience for this event. We appreciate our partnership with the World Affairs Council of Philadelphia and the great debate series they bring to the park each year. Tonight's discussion has its roots in the historic actions that took place right here so long ago. Tonight, we will again see how those actions continue to impact our lives today. History continues to live. The U.S. Constitution, debated and signed next door in Independence Hall, created the separation of federal powers between the judicial, legislative, and executive branches. Whether or not these powers were distributed evenly between the branches is at the heart of tonight's program. I can think of no better place to debate constitutional powers than right here in Congress Hall. This building was the home of Congress from 1790 to 1800. The House of Representatives convened in this room and the Senate upstairs. And right here next to me is where John Adams was sworn in as the second president of the United States on March 4th, 1797. When he took the oath of office, it was the first peaceful transfer of power between non-related heads of state, a significant milestone for our fledgling government. Millions of people visit the park each year to see in person the international icons Independence Hall and the Liberty Bell, both international symbols of freedom, liberty, and democracy. Independence National Historical Park not only cares for these and many other irreplaceable historic sites and objects, but also works to connect these sites to issues that affect us today. This is a great room, a great building, and a great park for inspiration and understanding of the foundations of our democracy and for envisioning our future. And you are a great audience for participating in this continued debate. Enjoy the program, which I know will be thought-provoking and inspiring. I'd like now to introduce Craig Snyder, President and CEO of the World Affairs Council of Philadelphia. Welcome, Craig.
Thank you, Patrick. We at the World Affairs Council of Philadelphia really prize this partnership with Independence National Historical Park, and never more so than in being able to hold this discussion here this evening. I also want to extend the heartfelt thanks of the Council to the Stan and Arlene Ginsberg Family Foundation for their ongoing support of our Great Debates programming, and to the Paul E. Kelly Foundation for its 70th anniversary commitment to support programming on liberty. At this moment of dramatic and extremely consequential confrontation between the President and the Congress that we are living through today, with crucial involvement from the judiciary as well, the power structures of our national government and the principles on which they were based, created in the building next door and first put into practice in this very room, in which we're honored to sit tonight. It's the aim of the World Affairs Council to replace some of the heat that's currently in the air with light on some of these fundamental questions about the roles of the executive and legislative branches, particularly under our Constitution. To help us sort through these matters are Paul Clement, partner at the Washington, D.C. office of Kirkland and Ellis, and the 43rd Solicitor General of the United States under President George W. Bush. And Joshua Geltzer, visiting professor of law and executive director of the Institute for Constitutional Advocacy and Protection at Georgetown University Law Center. Each of our guests will make a few minutes of opening remarks, followed by the three of us in conversation, and then, of course, some questions from all of you. With that, Josh, please start us off.
Well, let me begin by offering really heartfelt thanks to Craig, to the World Affairs Council, for hosting this, for including me. It's an honor to be part of this conversation, but especially to do so in this setting is a real treat. And it's a particular treat to get to do it with Paul, one of the true luminaries of American law, who's thought hard and passionately about the issues we're going to talk about tonight. And so I really am grateful to be part of this. Very briefly, let me offer three framings, three distinctions perhaps, that might be ways into the very big topic of the so-called Imperial Presidency and the relationship between the presidency and the other two branches, particularly the legislative branch. So here's the first one. You could worry, if you were worried about an Imperial Presidency, about stuff that a president is doing that you think a president should not be doing. So here you might have come to mind, under the current president, declaring a national emergency so as to move funds to build a border wall that the Congress had explicitly said they did not want to appropriate funds for. Or reimagining through regulation, proclamation, executive order of how to understand long-standing immigration laws in a way that some say are essentially rewriting rather than implementing those laws. That would fall into the category of a presidency doing stuff that one might argue a president shouldn't do. You might also worry, or you might instead worry, about a president not doing things that you think a president should do. So here you might imagine resisting congressional subpoenas, not providing documents, discouraging or disallowing witnesses from testifying, whether those witnesses are current employees of the executive branch or former employees. And it's worth considering which of those might worry you more. And I'll offer as a teaser that I think in some ways the second one worries me more than the first, but we can come back to that. That's one framing, that's one distinction as to what one might worry about if one's thinking about the imperial presidency, so to speak. Here's another one. You might think that presidents, really over time, reached out and seized power, took for themselves authority to do stuff that they shouldn't have. And they did so as the first mover, because often the executive branch is the first mover in our government. It's run by a single person, it's always on duty, especially in the area of national security. It's often that the president can move, and then the other branches have to come later and say, no, we didn't authorize that. We don't want you doing that. We never intended for you to use that money that way. Or you could think about the other two branches ceding territory. You might say not just ceding authority, but even ceding responsibility. And here you might tell a story of Congress over time writing statutes that are very broad and leaving it really for the president, the executive branch, to fill out the details, flesh out the specifics, even for the courts to do that a bit. Not mutually exclusive stories, but perhaps they would give you a different view of what it means to think about an imperial presidency. Third and final framing of this. You might think, if you think there is an imperial presidency problem, that the problem is in the laws on the books, or you might think that it's with how those laws are being interpreted. So some, especially over the past couple of years, who are critical of the current president, have taken aim at laws like the National Emergencies Act, or IEPA, and I always need to look at what IEPA stands for, the International Emergency Economic Powers Act. And they've said these laws give too much ground to a president. They indulge an imperial presidency. You also might look at those laws and say they were written to constrain presidents who were invoking inherent executive authority in these areas, and these laws actually set up guardrails, but you might not agree with how this president and his lawyers are interpreting those laws. So let me stop there, but I think those might be three different ways into the topic, and they might also yield a different sense of whether to worry about a president, whether to worry about this president, or whether to worry about the presidency writ large.
So, Josh, that's a great framing, and I think we'll probably come back to a number of those points. I want to just start by, echoing what you said about just being delighted to be here. I get a number of invitations to speak, but the opportunity to speak about the separation of powers in Congress Hall was not an invitation I was going to turn down. So it's delightful to be here, and I appreciate the opportunity to be here. I want to sort of kick it off with kind of 3 points, and what I'd say is the greatest framing thing is when Craig extended the invitation, my only hesitation was that if you wanted a debate and you wanted somebody to really take the executive side or the congressional side, I think the issues here are too important and too subtle and too nuanced for that. And he assured me that that people were open to not just a traditional debate, but really a discussion. I will say, and I'm sure Josh and I will find many things to agree on and disagree on before the discussion's over, but I don't know that you're going to find real disagreement on the high-level question of whether the executive has more power today than anybody who sat in this room in the first Congress or sat down just next door and framed the Constitution would have conceptualized. I think that's kind of an easy question. The framers, there's a reason they put Article 1, the Congress first. They thought that Congress would have an enormous amount of power and I think they would be somewhere between surprised, shocked, and gobsmacked by the amount of power that the executive has under our system. I just want to make 3 points that, again, I think of a little less as completely neutral framing points, a little more affirmative points, but I think they'll help frame some of the discussion. One is that Congress has certainly ceded power to the executive, but it's also lost power to the courts. And I think that's a piece of this we shouldn't ignore. This isn't just Congress versus the executive, but I think the framers would be as surprised by how robust a role that the courts play in our modern society as they would be by how powerful the executives become. I think, if the framers looked around and looked at who was deciding contentious issues like abortion and race, but even how to solve the opioid crisis, which is something that a single district court judge in Ohio is wrestling with right now, I think the framers would be very surprised that so much of this was being done by the courts. I also think they'd be a little surprised by how seemingly timid Congress would be about ever trying to, at least practically and successfully, revisit a decision by the courts. I mean, the single most important decision that the Supreme Court made when it sat 2 buildings down in Philadelphia was a decision called Chisholm against Georgia, involving whether a sovereign state could be sued by a private citizen. Just 13 months after the Supreme Court handed down that momentous decision, Congress, sitting in this building, proposed an amendment essentially to reverse it, the 11th Amendment, and that was ratified a year later. So I think the original framers would have thought that the court was deciding less and that Congress would have a role in reversing, overcoming, through the amendment process, those decisions that they thought were imprudent. The second point I make, and I think this directly follows from one of your framing points, but this is really a situation where, to the extent Congress has ceded authority to the executive, it really only has itself to blame. It has, most dramatically, by giving lots of authority to executive branch agencies. It has ceded a lot of what I think the framers would have conceptualized as the legislative power. When you look around the federal government and you ask, so who's dealing with the really hard issues about what emission standards we should have for vehicles, or how should we deal with immigration, and particularly the subject of citizens who have been here, or non-citizens rather, who have been here a long, long time and really don't have any place else to go. Should they become citizens? Should they be sent back? I don't know exactly where, but the whole situation of the Dreamers. And then even something as contentious as how to accommodate religious groups when it comes to something like the contraception mandate under the Affordable Care Act. All of those really contentious issues right now are being resolved by the executive branch and not by Congress. And it's largely because Congress ceded that authority away. Another recent example, but I think is another good example of where Congress took voluntary action that ended up empowering the executive at the expense of Congress, was Harry Reid's decision about a decade ago to get rid of the filibuster for judicial nominees. It was a Senate rule that had been longstanding, and by doing that, they really empowered the president, at least if he was aligned with the party with a bare majority in the Senate, to get nominations through very, very quickly. So a lot of this is, I guess I would say, a self-inflicted wound. The last point I just want to put at the beginning here is that I think one of the consequences of this, there are lots of consequences, we could talk about it all night and then some, but I think one of the consequences that's a little more subtle is that I think it's contributed to the era of partisanship and the extreme partisanship we have right now. Because the great thing about legislation is it requires compromise. I mean, if you deal with all these complicated issues that I've just talked about through a legislature, you're going to have to reach compromises. You're going to have to work across the aisle. When I worked briefly in the Senate, and I worked for John Ashcroft, later became Attorney General, but when I worked for him, he had just been governor for 8 years and was in his first term in the Senate. And one of his stock lines after serving as governor and being a senator was that anybody who told you that being a senator was more fun than being a governor would lie to you about other things. And the reason he said that is being an executive is kind of fun. You can get things done, and you don't have to compromise every single day to get anything done. Being a senator, at least in 1997, required you to compromise to get anything done. And I think as more and more issues get kicked over to the executive, that kind of sort of sense of compromise in the legislative process has been lost a little bit. And then the other odd thing, I think, is that if you let the executive branch do most of the legislating for you, there's not that much left for the Congress to do other than to take political positions and kind of partisan positions. I mean, somebody who's written about this is called, we now have sort of a Congress that's a parliament of pundits. And I think it's just easier for them to make speeches than it is to actually get legislation done, not because there aren't lots of problems that the framers would have expected Congress to solve, but because a lot of those problems have been kicked to the executive.
Thank you, thank you. Wonderful framing all around. So we start with agreement that the presidency is more powerful today than the framers would have conceived. Question, though, and that there are some negative consequences to that. But the question, I guess, that one of the questions is we're debating in the society today is how extensive that power really is. So several months before he became Attorney General, William Barr wrote a memo, famous to some, infamous to others, in which he argued for what some characterize as a kind of extreme version of presidential power, the unitary executive doctrine. And in the central thesis statement of that memo, as I understand it, he said, the president isn't the head of the American national government, he is the government. That seems, on the face of it, to run afoul of the well-settled doctrines under the Supreme Court in terms of the independence of certain federal agencies from the president, and the Nixon case doctrine that essentially the president's not above the law. Where would both of you stand on what the Attorney General has articulated as this unitary theory of the executive?
Well, I would resist the idea that the government resides in any one branch. This came up in a somewhat amusing way on Monday. There were arguments in a DC courtroom between the lawyers representing Don McGahn, the lawyers representing the Justice Department in resisting turning over certain grand jury materials redacted from and underlying the Mueller report, and attorneys representing the House of Representatives. I happen to be part of their extended team. And both the Justice Department lawyers and the House lawyers kept alluding to the government, which was really quite confusing because it wasn't clear if they were talking about themselves, the other party, something else. Eventually, the general counsel of the House said that we consider ourselves part of the government too, so I'll just use the Justice Department and the House from now on, which still didn't stop them from slipping into saying the government, because the tendency when you work in one piece is to think of it as the government. But the government is tripartite, including the very judges who were sitting and hearing this case, in a sense. And so, having been an executive branch lawyer and proud of some of the positions that we took, even though they were criticized on national security issues, scope of executive authority to deal with national security threats, to say that the president operates as the government rings true in a sense, because as I indicated earlier, the president's on call 24/7, and that enables and probably requires the executive to do certain things that judges don't do and that a Congress doesn't do. But that doesn't stop there from being other critical parts to the government. They just act in different ways, different timing.
Yeah, and I just offer sort of two thoughts to kind of contextualize this a little bit. I mean, one is, I think that, the idea that you want to have a unitary executive, I mean, that can mean a lot of different things to a lot of different people. I think at one level, it's a pretty uncontroversial statement, because it's clear that the framers wanted the executive branch to do certain things, and they had a long debate that you can see sort of spelled out in Federalist Papers, but they had a long debate about, so we need an executive, We weren't crazy about, the king. So what kind of executive should we have? And should we have some kind of, multi-member body? And they considered that, and then they squarely rejected it. So like at one level, it's pretty hard to argue with the unitary executive theory if what you mean is that when there are core executive functions, whatever they are, and I think maybe that's ultimately the harder issue, but whatever the core executive functions are, you generally want that to be discharged by the president and people who are relatively directly responsible to the president. We can debate sort of how directly responsible and the like, but I think, at one level it's not that controversial. At another level, I think that, as Josh says, it can't be that the president is the government, because that just ignores the other two branches, among other things. The other thing that I think ultimately is pretty clear is that you also do have to distinguish between the executive or the president or the presidency and the person who holds the office at any one time. And you see this manifested in an interesting way, I think, which is, whatever you think of kind of the current administration's conception of executive power, they've consciously made a decision that I think is the only decision they could make, and mirrored similar decisions that President Clinton made. But when in a lot of these lawsuits that are out there, the president is not represented by the Justice Department. He is represented by private lawyers. And in one of the important presidential immunity cases that's being cited back and forth by both sides in a lot of these debates, Clinton against Jones, in the Supreme Court of the United States, you had the president's private lawyer, and then sitting next to him as an amicus supporting William Jefferson Clinton's position, but on behalf of the United States government, was the Justice Department. So, I think in understanding this, a unitary executive that's either the whole government or even everything that has to do with the current occupant of the office, I think is too broad a concept.
So one of the controversies clearly in the present administration has been what is the extent of the president's power over the Justice Department, over the criminal investigative functions. The president and his supporters have appeared to argue that the folks who work in the Justice Department, who do criminal investigations and prosecutions, are at-will employees of the president like any other member of the federal government, that all of their power flows from the presidency, from Article 1, and that therefore there's a very broad latitude of power for the president with respect to hiring, firing, starting investigations, stopping investigations, directing the course of investigations. But there has been a tradition, perhaps it's sort of extra constitutional, but there's been a tradition in at least recent decades that the Justice Department has a great degree of independence from the president with respect to investigating the president or other members of the administration. Who do you think is right about this?
Well, so I'll kick this off because this is I literally could talk about this all night, but I assure you I won't. I served as the Solicitor General, which is technically the fourth-ranking official in the Justice Department, but it's also the official in the Justice Department that represents the executive branch before the Supreme Court of the United States. And there is a kind of long-standing tradition of a degree of independence, though maybe that's not even exactly the right word, maybe autonomy is the right word, but there is a long-standing tradition that the Solicitor General has certain responsibilities to the Congress, a special relationship with the Supreme Court. There has been a tradition of referring to the Solicitor General as the 10th Justice. As one of my predecessors pointed out, none of the 9 real justices tend to refer to the Solicitor General that way. But there is this sense that the Solicitor General is different. Yet, if you look at the organizational department for the Justice Department, you don't get that from the organizational chart. The Solicitor General works for the Attorney General, who works for the President. The Attorney General is removable at will. The Solicitor General is removable at will. You just don't you don't see on the organizational chart kind of, how this kind of independence or autonomy exists. And so to try to make my answer not too long, I think at some level, they're both right. I mean, the organizational chart doesn't lie. So there's no structural independence that's built into this. But on the other hand, there's a real long-standing tradition that what makes sense is to have a Solicitor General who ultimately on the big issues will keep the White House informed and ultimately put the White House in a position where if they wanted to put the kibosh on a position, there's no question they could. On the other hand, if they routinely did that to the Solicitor General, I would advise the Solicitor General to get a new job, because that's not the tradition, and it's not in the best long-term interest of the government for the office to function that way. There are other important traditions in the Justice Department, like to the effect that the White House really doesn't have anything to do with ongoing criminal investigations, particularly those that have been assigned to the Public Integrity Unit of the Justice Department. And those traditions, I would submit, are every bit as important as anything in an organizational chart. In some ways, the fact that they are long-standing, even though they're not in an organizational chart or a statute, probably tells you that there's a lot of thought and a lot of prudence by a lot of different executive branch officials in different parties over the years with different senates and houses of different parties. Some of these people had an easy job where the Senate and the House had the same party identification. Some of them had hard jobs where the House had oversight responsibility. But yet over all those years, they came to a certain kind of extra sort of statutory, extra constitutional understanding. And I think those things are very important, and how difficult they are to come by kind of shows you how important they are.
I think Paul put that beautifully, and maybe I'll just add to it two kind of thoughts from concrete episodes in the current administration. So it was at one point reported that the President Trump was thinking of firing Robert Mueller while he was still in the midst of his investigation, that at least included those within the president's group, perhaps the president. And like a lot of people, I thought as a matter of policy, of prudence, that would have been a terrible idea. Introduced into Congress around the same time was a law that would have protected a special counsel from firing by the president except for cause. And I also thought that was a terrible idea, but I didn't think it was just a bad idea. I actually thought it was unconstitutional. And this goes to the idea of the org chart and being able to, and we can get into the weeds of principal officers and inferior officers, but to have somebody who on the org chart reports to the president, as everybody at the Justice Department does, and who is supposed to carry out missions at some level of generality. Maybe not, probably not. Don't tell them to go investigate this person or that company or that entity, but to follow the orders of the president. That strikes me, to allow somebody to be shielded from that is at odds with the system that the Supreme Court has affirmed over the years involves principal officers being removable by the president. So really bad idea to fire Robert Mueller. And obviously this president did not ultimately do that, but there's a difference between propriety, policy, wisdom, I think, and sometimes what the law says. I'm not sure the law says. In fact, I think the law doesn't say that you could, by statute, protect that type of official from being fired from a president, no matter how bad an idea that firing might be. Another concrete example from the current administration that shows the complexity of these lines. This is not the first administration to decline to defend federal statutes in court, federal court as it happens to be, but they have done it in some very high-profile ways, and they've done it a few times, which is more than any normal administration. It's happened before. In fact, and when it's happened before, Congress has found decent lawyers to step in and make arguments, as Paul did when the Obama administration declined to defend the Defense of Marriage Act. But you have the current administration not defending the Affordable Care Act, not defending the criminal statute that criminalizes female genital mutilation. It's happening at a rate that suggests that whatever the word is, just like Paul, I struggle with the word, whether it's independence, autonomy, distance, but whatever the Justice Department should have, to do law, especially to do criminal investigations, but even just to do law, to say, look, Congress passed this law at some point, a president of some party signed it, and our job is to try to make it hold up in court. Whatever the policy position is of the current White House, it seems to me the bar should be really, really high for a Justice Department to step away from that duty. And yet we see it stepping away at a relatively high rate, at least compared to historical practice.
Thanks. So the push by presidents to extend the powers of the presidency hardly began with the Trump administration and the examples that you just cited. I want to talk about DACA, the President Obama's executive order to defend, protect the Dreamers, as they're called, and the current Supreme Court case about DACA. It seems to me, and there are many other issues that are like this, where when Americans look at that controversy and look at that case, they really evaluate it on the basis of whether they're for or against the policy, right? So if you think that the protection of the Dreamers is the right thing to do from a policy and a moral point of view, you want the Supreme Court to uphold the DACA order. And if you don't, if you have a different view of immigration, you want them to overturn it. But the Supreme Court's not supposed to be making the decision on that basis, right? They're supposed to be making it on the basis of whether or not the statutes and the Constitution give the president that power. So putting the policy argument aside, I want to ask both of you about what you think the right decision in this case is. Did President Obama have the power to protect the Dreamers in the way that he did as a matter of prosecutorial discretion under the existing immigration laws, or was he in fact rewriting the immigration laws because he didn't like what Congress had done?
You mentioned it before. You want to take a first stab?
Yeah, I mean, I'll say, you know, I'm not sure I know enough about the details of all of the cases to have a definitive answer to your question. But I guess I would say, you know, I did mention it before, and this just seems to me to be the classic issue of an issue that the framers would have thought that Congress would tackle rather than the executive branch. So even if President Obama had the power to tackle this and whatever power President Trump has to untackle it, it just seems like a classic issue. The stakes are sufficiently high. It involves an issue of obvious national importance. It's contentious, but ultimately it is really, as you say, people react to it as a policy issue. And, you know, Congress could come up with a solution to it. If Congress had come up with a solution to it, it would have forced people to work across party lines a bit. But whatever they came up with then would have been a durable solution. And one of the other problems with having this transfer of authority to the executive branch, and it's part of what I think contributes to kind of the partisanship, is even assuming that President Obama had the ability to deal with this issue by executive order, the one thing that's crystal clear, and I don't even think the litigants in the case before the Supreme Court really doubt this, is if the next president comes in and says, as a matter of executive discretion, I want to discontinue the policy that had been adopted by executive order, as long as they comply with the APA and the like, they can do that. And that, I think, is a great illustration of why, if you kick these issues over to the executive branch, even where the executive branch has the power, it tends to create these kind of binary partisan solutions where, you know, you kind of know that in the presidential election, if you vote for one party, you might get a whole bunch of executive orders on a whole bunch of policy issues that will just disappear or go from one direction to the other. And again, I don't think that's something that the framers had in mind. And just the last thing I'll say about this, and this does get to the issue that's currently before the Supreme Court, one of the things that's interesting and kind of shows the problem here is, you know, I think if you ask the question, why does Congress cede some of this authority, is that, you know, sometimes it's hard to make decisions and be responsible for the decisions you make. And it's telling, I think, in the context of DACA, that the real issue before the Supreme Court is that the Trump administration, in changing the policy, has basically said, we don't think that President Obama had the authority to do this by executive order, so we don't think that the executive branch can continue to execute this policy. So they didn't say, as a matter of policy, we want to change gears. They said, we think our hands are tied, and so the story of the DACA issue is really Congress kicks the issue to the executive branch, and now the executive branch is basically kicking it to the Supreme Court and trying to get them to decide once and for all whether the executive branch has this power with the effect that it will decide the policy issue.
It is well, great and disturbing case study for all the reasons Paul lays out. And, you know, just to zoom in on his point about what Congress actually legislating does, namely it forces compromise, there's this relatively new book out called Border Wars by two New York Times White House correspondents, Trump on Immigration. And it's not only the story of DACA, but as you would imagine, DACA makes recurring appearances. And at various points, there are various deals. And it's senators and members from both sides of the aisle who have different ideas about what to do with the Dreamers or how to tie the Dreamers to other issues that the president or they care about, dollars for the border wall, other immigration issues. That's deal making. That's what we expect, and I think rightfully expect of Congress to do. But none of those deals got done, which is why they didn't get done in the Obama administration. They didn't get done in the Trump administration. And so this sort of slow motion kicking of the can just has made its way, as it sometimes does if the stakes are high enough and if the legal arguments are significant enough, to the Supreme Court. But that's only because the deal-making never culminated in Congress figuring out what to do on an issue that they actually have spent a lot of time trying to negotiate on, but they haven't reached something sustainable. They haven't actually passed a law and gotten the president on board to pass a law. Now, where I stand on the case, I'm guess, already pregnant with a position on this. I've part of a team that filed an amicus brief in the case challenging the termination. And our signatories are largely law enforcement officials. They're people who say, look, something like DACA is critical to sheriffs, police chiefs, prosecutors being able to get communities to come out of the shadows, so to speak, report crimes, cooperate with investigations into crimes, show up as witnesses when crimes are in fact prosecuted in court. And that argument is one that gets made in part because this has been this state of suspended animation. That's why you have an amicus brief like that getting filed amidst all sorts of legal arguments in the case. But you have it there because there's a sense that we haven't really gotten an answer from our federal government on what should be the fate of this group of people. And so the idea of a retreat into the shadows is at least on the table, whether you think of that as legally decisive, a policy matter, whatever you think of it, it's on the table because there hasn't been the sort of resolution that, to go back to where we are, you would think the body that used to meet here would be on the hook for, which is pass a law, entrench it, everybody knows then where you go from there. And instead you have this enduring set of question marks.
So Congress kicked it to the president kicked it to the Supreme Court. So I'm not gonna let either of you kick it. I wanna ask for a prediction, in effect, about this case. I wanna stay on DACA just for a second and ask for a prediction about this case. I guess one could argue that it's likely that there are 4 justices on the court who would like to rule in a way that would, in effect, make the immigration, the criminal law under the immigration code, a kind of strict liability offense. And if you're here and you shouldn't be here under that law, action should be taken against you. And there are probably 4 justices on the court who would argue that the president has the authority to, as a matter of prosecutorial discretion, prioritize enforcement and, in fact, simply not enforce the law with respect to a large category of people, the Dreamers, and perhaps others as well. And then there's one justice that's going to decide which way that goes. It's a very monumental decision, given that the 2 political branches of government have not sorted this policy out in the way you've described. The court's going to decide it. What do you think is going to happen?
I'll let the former 10th justice make a guess about the other 9.
I think a lot of my sense is that a lot of people watching this were kind of counting votes similar to where you were, and that I think, and you were involved in it directly, and I wasn't. But my sense is that the people that were challenging the administration's policy, I don't think they got a lot of comfort in the questions that the Chief Justice was asking, and so I tend to think that the case will come down on that side. But even so, there's a lot of different ways to write this opinion. And there may be ways to at least try to kind of kick this issue back to the political branches, because the most the court would be deciding is that the authority doesn't exist under the current set of immigration laws, and they certainly wouldn't be saying that the Constitution requires that the Dreamers be sent out of the country. So I think that's kind of what my prediction would be, but I also think, particularly if it ends up being written by the Chief Justice, that you might see some language that kind of echoes a little bit what we're talking about, because I don't think the court wants to be in a position where too many of these issues get kicked their way.
That sounds right from the coverage I read of how the argument went. And what's interesting is there are some cases that present as being sort of a single, crisp legal question, but very few make it to the Supreme Court that way. And here, even to try to figure out what would be, if you wanted to simplify it this way, what would be the pro-executive branch decision by the US Supreme Court here? I mean, is it to think that the Obama administration did have the authority to prioritize enforcement in the way that it did when it announced DACA? Is it to think that a later administration has the right, the Trump administration, to come along and say, we want to pivot away from that, either because, as Paul indicated, we think as the executive branch it was unlawful to do that in the first place, or because it's within our power to pivot even if there's a legal availability to that approach? Is it to accept the arguments of the current executive branch, which certainly are to allow the termination of DACA that the executive branch announced and intended until it got litigated? These things aren't as clean and as easy to say what's the pro-executive or what's the anti-executive authority position. And it does seem, given the human stakes, that there was interest from justices in trying to figure out a way that, as the political branches have done, tries to figure out a sort of humane resolution to a lot of people who've been in this country a long, long time.
So I want to turn to war powers. And I think one can make the argument that if there's a sort of single leading reason why the presidency is larger today than it was conceived of by the founders, it would be because, as you've said, Josh, the presidency is always on, it's on call, and in the modern world of short time durations to make decisions about the use of force, in many cases, that it just seemed sort of natural that the president would have more authority because of being the commander-in-chief. I guess to make that a little more crisp, don't you think it's the case that once we, as a society, decided that a president could, on his own, launch nuclear weapons, that meant that the presidency became clearly first among equals with respect to the branches, that there was a sort of inherent degree of power that just simply wasn't conceived at the time of the Constitution?
I'm happy to take a first stab. I mean, maybe I'm not going to fight the premise, but maybe chisel it down a little bit, if I may, which is there are certainly views of the Office of Legal Counsel at the Justice Department and other national security lawyers who've worked in the executive branch, which could justify a president, as you say, Craig, using a nuclear weapon without checking, so to speak, with Congress. But I'm not sure I'd phrase it exactly the way you phrased it, which is that you kind of have that just available to you. Instead, the doctrines begin with, is there an imminency of the threat such that it would trigger Article 2 exclusive powers, meaning presidential powers, to do something that defends the nation? That's a doctrine that has emerged from the Civil War and the steps Abraham Lincoln took notifying Congress, as he pointed out in later arguments of the Supreme Court, calling it back into session, but that he did take on his own, that the Supreme Court later essentially ratified. And then it's taken that and, of course, cranked it up with technology and the speed of activity. But that's not, to me, to say that there's just a weaponry sitting at the president's disposal. Certainly, as a national security lawyer, that's not how we thought about it. Instead, there are Article I responsibilities to declare war, make war. Then there are doctrines about when activities undertaken by the executive branch are short of war, and there's an overlap here, short of war and responding to a threat of a certain imminency, that it would be maybe even irresponsible for the executive branch not to respond. That's what Abraham Lincoln certainly said. So if I didn't respond in some way, we wouldn't be having a debate at all about the separation of powers, because we wouldn't be having a country anymore. So you can agree or disagree with the doctrine on this. The best external manifestation of the doctrine are some of these Office of Legal Counsel published opinions. You can also disagree with some of its implementations. Fiercely debated the Libya intervention. Fiercely debated when the Trump administration fired missiles at a Syrian airfield. But to me, the doctrines emerge from a real grappling with where Article I and Article II fit into defense of the nation.
Yeah, and I guess I will try to push back on the premise a little bit, because, I mean, you're right, that once you have nuclear weapons and you have the ability to launch nuclear weapons in some sort of either affirmative or offensive or defensive way, that does give the president a practical power that's enormous, but at least in an offensive way, in a non-declared war, it's never been exercised. Mm-hmm. And so it seems to me that a power that's never been exercised cannot sort of, definitively transform the separation of powers, and shouldn't. And then, just to push back a little bit more on the premise, it was just a question, to be sure. It wasn't a thesis. But, I think sometimes we lose sight of what the framers were dealing with. Because, the framers kind of knew that something like the War of 1812 would happen. They were dealing with a time where it was much harder to assemble the Congress, and so some reservoir of authority in the president to defend the country, I don't think the framers thought that, if a British or French, ship attacked neutral American vessels, that the president should do nothing until Congress could reconvene. So from the very beginning, Congress had an idea that there were a reservoir of, call them emergency powers, whatever you want to call them. I think the framers had that in mind from the beginning, and yet still thought that Congress and this building had an awful lot of responsibility when it came to not just declarations of war, but foreign policy and the appropriations for the military, how the military would be structured. All of that was designed to be done through legislation, primarily, at least the backbone of it. And then where they really expected the executive branch to come in is in the execution of that policy. Now, as Josh alludes to, that means that I think there's a reservoir of authority to do things where Congress probably shouldn't try to second guess. I mean, if you're at the level of which enemy combatants are we going to capture because we think they have important information, if you are in a declared war, not that we've had one for nearly 100 years, but if you were in a declared war and you got to the issue of what hill should we try to take, I mean, that's precisely what the framers didn't want decided by committee. So I think, as much as I think the balance has shifted demonstrably to the executive in other areas, I think in this area of the war-making power, from the very beginning, I think Congress thought it was going to be active in some of the big decisions about whether we'd be at war. But I think from the very beginning, they did think the president would be responsible for executing the war once it was declared.
And if you'll indulge me, let me just pick on Congress for another minute. We haven't done that in a few minutes, so it seems appropriate. This goes back to the theme of, yes, presidents have acted. They have, in a sense, taken power, if that's the view, but Congress has given it away in a sense. So as somebody who was working in the National Security Division of the Justice Department, there was a view, I defend it, I would still defend it, it's controversial in some quarters, that US military force against ISIS fell within the scope of the authorization for use of military force passed in September 2001, which of course at the time ISIS did not exist, and ISIS in some ways has rejected, split from the organization Al-Qaeda that was among the main entities Congress had in mind then. Now I can give you the reasons why I think that's a fair, defensible interpretation of the 2001 AUMF, to apply it to an organization that emerged from Al-Qaeda, but it's a controversial interpretation. And as the Obama administration offered up that interpretation publicly, acted on that interpretation by using military force against ISIS, it also did something else. It sent over a proposed new AUMF, authorization for use of military force, to Congress, and said, let this be the beginning of a dialogue. Realize that old one has been sitting on the books for a while. Realize some of you don't like our interpretation, applying it to this new terrorist group. Let's either update it or add this one so that we're on even firmer footing, so that we do the thing that Constitution says we should do in terms of passing laws that authorize executive action. It's been years now, and that hasn't happened. Didn't happen under the Obama administration, didn't happen under the Trump administration. There have been hearings, there are some senators, Senator Kaine in particular feels very strongly about this, but it didn't lead to what Paul was talking about before, which was actual negotiation and compromise, and then the end product, bicameralism and presentment, actually passing a new federal statute. So to the extent there's a gripe with the executive branch interpreting a law like the 2001 AUMF, maybe a little more aggressively rather than a little bit less, it isn't like Congress has stepped up to actually get behind a new law when national security threats would seem to demand it.
So limited time. I want to turn to impeachment, the 800-pound gorilla in the room.
We knocked out all the easy ones.
Yes, exactly. I want to go back to the Attorney General for a minute, who recently gave a speech in which he said, quote, "The left is engaged in a systematic shredding of norms and undermining the rule of law with respect to this impeachment process." And other things as well, but mostly with respect to the impeachment process. Of course, those claims, shredding norms and undermining the rule of law, are what the proponents of the impeachment inquiry say they are trying to stop, that they're defending against. Who's right?
Obviously, I'll let you take this one first.
So, look, I think impeachment is one of the, there are a lot of issues, even that made it into the Constitution, that the framers didn't really debate that much. I mean, there's whole clauses that have become very important that got in there, really without, extended debate. I just got appointed to get involved in a case about executive power to remove officers. And it's been a very contentious issue for 200 years, but the framers didn't say a word about it. They thought a lot about impeachment, and they thought a lot about where to put the power of impeachment. They thought about potentially getting the court involved more directly. They thought about getting some kind of, they thought, outside of the boxes that existed at the time. They thought about getting like a council of governors that would do it. And they came up with the system that they ultimately came up with, which was one that got the House involved in a particular role, got the Senate involved in a particular role. They got the Chief Justice involved if and only if it was a presidential impeachment. One of the interesting things about the impeachment process that I think makes it kind of hard and requires, I think, some subtle thinking, is that other than the Chief Justice's involvement, the rest of the impeachment process is the same, whether you're impeaching one district court judge out of 800, whether you're impeaching a cabinet officer. It's only been done a couple of times, but if you want to try it, it's the same, and the president. And so I guess what I would say is if I were advising the House in conducting this impeachment proceeding, I would probably advise them to err on the side of procedure. And, I think I think given who's doing the impeachment process, the House and the Senate, I mean, it's inevitable that there are going to be accusations, if it's the president, that this is all partisan. I mean, you definitely had that in the Andrew Johnson impeachment. You definitely had that in the Clinton administration impeachment. You had that up to a point in Nixon, and then it kind of crossed over the threshold. But I think that's, if it's the president, you're always going to have that. You don't have that dynamic with judicial impeachments because generally they don't even try to do it until the judge has been convicted already. Another instance in which Congress has kind of kicked a lot of the hard work to another branch of government. But so if I were advising the House, I think I would say, look, this is going to be a partisan process, or it's going to be perceived as a partisan process, no matter how careful you are. So you should be as careful as possible and try not to sort of give opponents relatively low-hanging fruit by saying that you're doing certain things without a vote, you're doing things in a way that's different from the way the same issues are handled in the Nixon administration, the Nixon impeachment process, the Clinton impeachment process. My advice to them would be to sort of cling to those precedents as closely as you can.
I think that's wise. In a sense that you could say that the freedom, or at least the lack of specificity in the Constitution or anything else about aspects of impeachment creates a responsibility, right? Because it sets up, as Paul indicated, a fascinating sequence, but doesn't fill in a lot of how that sequence should go. And then it makes it incumbent on members of the House and then senators to fill in those gaps in a way that's responsible, in a way that educates the American people along the way, whatever view the American people, whatever view this House and Senate want to come to at the end, that lets people understand what's going on and what the stakes are as well, what the accusations are and what's behind those accusations. I think that also is true of the executive branch, right? To have a fairness in how they approach the process. So I previewed in the couple of remarks I made at the beginning that in some ways I'm more disturbed by what I see as executive branch, at least right now, not doing certain things rather than doing certain things. And part of what I had in mind here is a memo from the White House counsel, which is reflective of a broader posture that almost says impeachment, I read it to say, and others read it to say, impeachment, we won't be playing that game. We won't be cooperating with that because we think it is fundamentally illegitimate. We think it's trying to reverse the results of an earlier election. And impeachment is not a game, but to the extent you use the metaphor, you do need to play it if you're the executive branch. Now that leaves a lot of room still to fight over scope of privilege and which documents and whether there are redactions and what to share with Congress. There's a lot of room to, on a good day you'd call it negotiate, on a bad day you'd probably call it fight about. But to declare resistance to the process as a whole, which is how I read the counsel's memo and frankly some of the litigating positions of the current Justice Department now, that strikes me as also taking the flexibility, taking the lack of specificity about impeachment that in the actual text of the Constitution and going too far with it, being irresponsible with it. And the reason that this concerns me so much is because if one thinks that there is this kind of ultimate penalty to be handed down by Congress to the executive branch, the ultimate penalty of taking a president out of office, it needs to be able to understand whether to do that and why to do that. So the resistance to even providing the information that lets Congress make that assessment, that strikes me as in some ways more concerning because it gets at the oversight, the check, in a way that any particular affirmative action by the executive, spending money this way or deploying troops this way, doesn't. So it brings us back in some ways to those types of concerns, perhaps, if you're concerned about an imperial presidency.
Yeah, and if I could just add one point about that. I mean, I think this is where the partisanship which, I think is fairly attributed, at least in part. There's a lot of different sort of sources of it. But I do think part of it stems from kind of congressional inaction, congressional seating authority. But then if you get to this point where, people in Congress are not used to working across the aisle, they're not used to compromising, and then you throw impeachment in the middle of that, which is the hardest single thing to think about in a neutral, bipartisan way, and expect that to end well. I think it kind of shows you that we've gotten to a situation. I think the conventional wisdom is that impeachment will happen in the House because there's X number of votes there from one party, and that there won't be a conviction in the Senate because the partisan makeup is different. And I think, whatever that way of thinking is, if you're in a world where people have just gotten out of the habit of working across the aisle, they've gotten out of the habit of legislating, and I think part of the way, again, just to try to make the link, is if the Congress isn't actively wrestling with the most difficult issues, and it's kind of watching the executive branch wrestle with the most difficult issues, then it becomes entirely natural for the senators and congresspeople of the same party as the president to sort of be a cheering session for the person who's on their team who's dealing with the problems of the day. And it's perfectly natural for the people in the opposing party to take shots at everything the executive branch does. And so not only are they not affirmatively working together to solve problems, but they're both kind of watching a game on the other end of Pennsylvania Avenue where they're both taking sides and getting driven further apart. And again, to take all of that and then say, okay, but it's really a shame you aren't working together on impeachment, I think is really asking too much.
What's a high crime and misdemeanor? What did they mean, the folks who worked in the building next to this? Does a high crime and misdemeanor have to be a crime? Or is it really a political judgment, in which case, in a partisan world that we live in, that they did not live in to the same degree, it becomes a goalpost that's easily movable?
So I'm happy to jump in and just take a first crack at it. So, if you look at the impeachable offenses, you have high crimes and misdemeanors, which is this awesome phrase, because even in 1789, it wasn't in common currency. So the framers picked kind of an odd phrase, I think, on purpose. But they also picked bribery and treason. So that tells you something. Now, one of the interesting things, and it's relevant to what's going on today, I think it's probably relevant even to the Clinton impeachment, is I think what the framers had in mind was receiving bribes, not necessarily giving them. But that's you can argue about that, but I think that's the gist of it. But I think bribery, at least if you think about it in terms of receiving bribes, it's a corruption of the office. It's being unfaithful to the charge of the office. Treason, I think, is pretty obvious as being sort of disloyal to the nation. I think all of it get to this idea of kind of not putting the nation's interests first. And so I think when you get to the question of, I don't think every crime is impeachable. And I think that there is some conduct that's not criminal that's impeachable. So if you think about it in Venn diagrams, I think a lot of what's a high crime and misdemeanor is also probably a federal felony, but there's some stuff that's not. And, like I said, there's, I think if, certain, if you engaged in insider trading while in the White House, that would be really, really bad, and you pay whatever penalty you're supposed to pay. It's not obvious that constitutes a high crime and misdemeanor. So and the one other thing I'll say that they talked about next door that's worth keeping in mind is the one concept that was also being kicked around but was ultimately rejected was maladministration. So, one way to think about this is, so just doing a lousy job, which is what I take maladministration to mean, is not enough. Taking bribes and treason is absolutely enough. And then the framers, I think, wanted there to be some play in the joints. I don't think they wanted high crimes and misdemeanors to be whatever the House says it is. That's not what they meant. They wanted the House to actually try to wrestle with what constitutes that. And I think it's a hard question. I think it's a really interesting question, but that's to say, when at least kind of show where the goalposts are, that's the best I can give you.
It's more than that. It's a great rendering of it. And I agree, just to start with that famous quote, that it's whatever a majority of the House says it is. As a matter of raw political power, I guess that is technically true, but I sort of hate that quote because it suggests that that if you're a member of the House, you're let off the hook from doing the hard work that Paul is pointing to, which the Constitution seems to point to, which is not to just nose count, but instead figure out what was meant by that or what it means as applied to whatever scenario is before the House in any given impeachment inquiry. So I think there's a pretty broad consensus. Never want to say a total consensus, but a pretty broad consensus about the exact sort of Venn diagram that Paul mentioned, where crime doesn't mean federal felony, but a lot of federal felonies, some federal felonies, maybe a lot, probably qualify, or even just federal crimes. It's not even clear that some of the words we use when we talk about impeachable offenses, words like obstruction or even bribery, that the Constitution demands that the elements, so to speak, the elements that I guess House and then Senate would need to find, that the elements need to be the exact elements of those crimes as found in the US Code, though I would think that it's a decent guide. If you have to start somewhere, you'd start with what Congress at some point judged those words to mean in the context of the Federal Criminal Code. But it doesn't mean that those need to be the exact same things as you evaluate what are impeachable offenses. I think you zoom out far enough and you get to something like breach of fiduciary duty. People have talked about the presidency as its own form of fiduciary-like duty to the nation, that you serve the public interest rather than a private interest, you serve the nation's interest. You're allowed a lot of leeway to think about what that means. I mean, that's what presidential elections are about, very different visions for what the public interest is and how to go about effectuating it. But when there seems to be something that betrays the public interest for a private interest, a parochial interest, that seems to be the sort of breach of fiduciary responsibility, the sort of abuse of power or of office that gets you in the right ballpark, I think, for thinking about, guided there in part by words like bribery and treason that are in the Constitution, but gets you in the right ballpark for impeachable offenses.
Thank you both. Going to take some questions from the audience. Got a microphone that's going to come around.
Sure, I'd like to know if one or both of you could talk about perhaps the court's role in this exchange of power, or change of power between the executive and the legislature, particularly the sort of moribund non-delegation doctrine, which seems to have gone away since the 1930s.
So the non-delegation doctrine, what's it said? It's had there's a famous quote that it had two
one or two really good days.
Good days and 99 bad years or something like that. The idea behind it is that if you're the legislature, you should legislate. You should pass laws that have what the Supreme Court has called an intelligible principle, something that doesn't just kick it all, so to speak, to the executive branch. As I kind of indicated before, it seems like there's an increasing inclination when Congress actually does pass a law to kick as much as possible to the executive, which has in some ways revived the idea of challenges based on this. One of the arguments made by those who challenged Trump's travel ban was that if the immigration law and the emergency provision that the president invoked was so broad as to allow a dramatic overhaul of the type that the president's third travel ban, the one that went to the Supreme Court, effectuated, that there must be a non-delegation doctrine problem there. But the Supreme Court didn't buy that. The Supreme Court also heard recently another case. Were you involved in the Sorna case? I'm sorry, I should let you.
No, I was not. Yeah.
Where there was a challenge to a piece of the Sex Offender Registration Notification Act that Justice Gorsuch, when he was merely Judge Gorsuch, had indicated he thought was a non-delegation doctrine problem. For some valid reason. This was a piece about how to apply this law to pre-enactment offenders, and it seems that Congress actually talked about it a bit, decided that question was really hard, perhaps on legal grounds, so whether you could apply it retroactively, at least on policy grounds, and left it to the executive branch, said, you sort out this piece of applying this law. So there was a challenge brought called Gundy. Again, that challenge failed. But it seems like there is this doctrine there that folks like Justice Gorsuch have clearly thought very hard about where are the limits of Congress leaving it and saying executive fill in, not just the pieces. There's a long tradition of saying the executive branch should issue clarifying, implementing regulations, but doing something that looks like it's actually finishing off the law itself.
And the only thing I would add, and I think I agree with everything you said, but the one thing I would add is, I do think the non-delegation doctrine and, the interest in that and the revived interest in that does kind of illustrate one of the issues I tried to identify in my opening, which is, if the problem is that Congress is voluntarily ceding too much authority to the executive branch, it's its own problem if we think the natural solution to that is to run into court and have 9 unelected judges tell us exactly where the line is between what Congress can give to the executive and what Congress can't give to the executive. And it really does seem like Congress has lost power to both branches, and at some point, we try to talk about like what's going to get Congress to change its mind, and I think there are possibilities, but it's difficult. But at some point, Congress has got to step up and stop giving its power away, because I think the reason that the courts have struggled with the non-delegation doctrine is, I don't think the framers necessarily anticipated that Congress would give its power away voluntarily. So I don't think there's a provision in the Constitution that says this much and no further. And without that provision in the Constitution, the justices probably don't have much of a business trying to get involved in the issue.
Please.
Very glad to be here and get taken to school. I'd like you to expand on something that ties back to what we hear about in tweets every day, which is the phrase deep state, which I've heard of that phrase in terms of third world countries many times, but now we hear it every day here. So we have 2 examples of where the tradition that you talked about, Paul, was utilized. And what I want to understand from each of you is this an example of the deep state or not? Example 1, right after the inauguration, the president called up the attorney for the Southern District of New York and said, hey, I want to talk with you. The attorney, Behera, didn't take the call. The president calls Comey into his office, says, let's have a little chat. Comey didn't want to be left alone, stranded. Comey goes out and dictates notes immediately. So here's the question. Given tradition, did each of those members of the Department of Justice handle their job the way you think it should have been handled, or should they have handled it differently?
Well, look, insofar as those instances, right, saying, Mr. President, as I gather, Preet said, Mr. President, maybe we shouldn't talk directly. I mean, the U.S. Attorney, Comey indicating that he wanted to take things down. I'm not sure either was legally obliged to take that step, which is another way of saying I don't think there's anything in Constitution, law, statute that prevents the president from speaking directly to a U.S. attorney, an FBI director, or probably just about anyone who works for him, with maybe some exceptions depending on if you knew somebody were actually investigating you. There might be ethics or conflicts laws that kick in. But I'm not sure there's a legal violation there. But it goes back to the prudence and the tradition that I think we were both talking about before, in which the Department of Justice, and the FBI director works for the Department of Justice. They don't always like to acknowledge that, but they do work for the Department of Justice, and certainly U.S. Attorney works for the Department of Justice. There's some space meant there. The ideas animating that, I think we hit on before, which is, especially in the criminal realm, you want a White House dictating who gets investigated for crimes, prosecuted for crimes. You probably don't even want them to know that that's happening. It's not always true. In the national security area, if there was going to be a major arrest of a terrorism suspect, and this is written in to the memos that govern this, you actually do want people who can coordinate a response that puts embassies on high alert or helps secure Defense Department bases. You do want somebody to know. So it's not a never, but in general, you want to keep some space. And in general, you want an FBI director to investigate according to the traditions and the leadership of the Justice Department with some distance from the president. So I'm not sure there's a legal violation in either of those conversations. On the other hand, I think there's probably prudence in people who understood how those traditions have been operating, trying to create a little space in the face of a president who didn't seem to be inclined to go along with those traditions, maybe not even be aware of those traditions. That's not to say I think everything that those two did thereafter was the right call, but those two reactions strike me as attempts to try to stick with the traditions as those two actors knew them.
Yeah, and so, I know Preet, I know Jim, so I want to, I don't want to necessarily second guess the decisions they made. And, I think you can be the U.S. attorney for the Southern District of New York, and, I've had a couple of friends who've had that job, and, they think they're like a U.S. attorney like no other. But again, if you look at the organizational chart, it's just 1 out of 93 offices. But you could be U.S. attorney for a long time without getting a call from the president. So it's a situation that I don't know that there's just like something in the U.S. Attorney's Manual that tells you exactly what to do in that situation. So I have the advantage of having more time to have thought about it than either of them did in the particular circumstances. I guess though, kind of building on what Josh says, there's nothing sort of wrong in principle with the call. At least I don't think so. I mean, I think there are sort of some, particularly calling a U.S. attorney directly, it's not how it's usually handled, but there's nothing wrong about it. And I guess in a sense, I think if I were in that position, I probably would have taken the call or had the meeting. But if it became clear to me, kind of very early in the conversation, that kind of the president was either asking about things that could be sort of inconsistent with those traditions, or just didn't really have a sense of where the kind of lines were, I think I would want to affirmatively try to lay down those markers and to really try to, in a sense, help. And look, everybody's views about the current occupant of the White House is such an overdetermined equation. But if you just take a step back and try to think about those early days, it's been a while since we had a president with less governmental experience before walking into the Oval Office. And so, I do think rather than just sort of wait for him to ask something inappropriate, in that circumstance, dealing with that kind of just elected president, I would think that if I were in those positions, one of the things I try to do is, make clear what the longstanding traditions are, make clear that they're actually, it might not be obvious there. I don't know that you get a manual when you get elected president. It might not be in there, but there is a longstanding tradition of, doing things in a certain way. And I think it would be perfectly fine if, say, a U.S. attorney wanted to make it a pretty brief phone call by making clear that, in the ordinary course, it'd probably be better for us to, if there's something you want to talk about, there's probably, it might be appropriate for us to meet with the Attorney General. And I'm happy to come up to Washington tomorrow to do, there are ways to do it that, again, but I've had a lot of time to think about it. And I'm not, in the position where, well, that's, it's a blocked phone number. I wonder who that could be. So.
I'm going to ask one last question as we're running out of time. And really, I ask you this as much as citizens, as attorneys and legal scholars. There are 71 members of the House and 14 senators serving today who served during the Clinton impeachment 20 years ago. And as near as I can tell, every single one of them is on the opposite side of where they were then in terms of what they're publicly saying about what is impeachable and what the role of Congress is. So have we really come to a point where it's questionable whether we have a government of laws, and in fact we just have these two warring political tribes who will switch sides on their interpretation of the Constitution, depending on the party of the issue at the moment.
So I'm going to let you go first because, believe it or not, I can actually end this on a somewhat optimistic
Good.
note.
I will
Good.
lead good.
Good.
And I'm going to lead into that as well, which is, look, I don't think many people like the tone, the rhetoric of politics these days, and getting to come here is a nice, in fact, excuse to get out of Washington a little bit. But I do think we're operating very much under a rule of law, even if some of us are, as Paul has been, as I have been, engaged in a debate as to what that is. And it may look particularly rough and tumble in Congress, but the impeachment context, just as Paul was saying, may bring out the worst in Congress, A, because of how fraught it is, the stakes are so high, and B, because it does blur politics and law in a way that I think the constitutional design demands, but really, really is hard for those who are used to speaking a language normally of politics or at least policy rather than law. But you go into a courtroom, type courtroom I was describing Monday, you go into the US Supreme Court, you go into district courts around the country, and you still see the rule of law being done. I may be on one side of a case and disagree with the positions espoused on the other. I may not love the rulings handed down by this judge or that judge on a given day, but there is still a debate that happens there as to the very issues we're talking about here. Some of the things I brought up have been challenged in court. The scope of the 2001 authorization for use of military force, the travel ban, DACA's in court, whether declaring absolute immunity from testifying when served with a congressional subpoena in the impeachment context. These things are being hashed out by lawyers in front of judges, maybe slower than we'd like, maybe with a whole lot of tweeting and other noise around them, but I still think there's a lot of law happening too.
So my optimistic note is it roughly goes as follows. So I've been teaching separation of powers at Georgetown Law School for something like 20 years, and it's given me a little bit of a kind of longer term perspective on this. And one of the lessons I've learned and try to impart to my students is that you really can't think hard and get to a clear answer on a separation of powers issue until essentially both political parties' oxen have been gored by a particular practice. And it's only at the point where the shoe has been on the other foot that you can start to see that something like the independent counsel statute, for a prominent example, is a bad idea. When the independent counsel statute was first being used by Lawrence Walsh to investigate President Bush 41, there were a lot of Democrats who said, yeah, this is great. But then when Ken Starr was using the same statute to investigate President Clinton, people were switching their hats, and Republicans were saying that things that they'd been saying, oh well, maybe it's not so bad. But ultimately, after both parties' ox was gored by that statute, both parties got together and said, let's not reauthorize that statute. I think something similar is happening right now with the issue of nationwide injunctions, which is an issue that when I was in the SG's office, we first started to see with President Bush 43, where a single district court judge in one part of the country would enjoin an executive branch practice all across the country, which to me didn't seem like the right answer. It seems like these cases are supposed to work their way up to the Supreme Court, and so it's fine to enjoin the practice over here, but let a court over in California decide it differently if it wants, and then eventually it can get up to the Supreme Court. The Obama administration had to suffer through 8 years of nationwide injunctions with increasing frequency. Now they've kicked into even a higher gear with the Trump administration. And although there's still people who are going to argue for nationwide injunctions, and look, I'll do it for a plaintiff if it suits my plaintiff's interest. That's what lawyers do. But I think enough people have had experience with this on both sides that a consensus is starting to emerge that there's got to be some check on them. And I think something similar could happen with impeachment. I mean, we really, now that we've had sort of two impeachments where there's at least a working group of people that were there for both of them. Yeah, they're gonna say what they say today, but they might be able to calmly, when this passes and this too shall pass, they may be able to say, we really ought to, maybe we should maybe we should have a little committee. We're not doing much else. Maybe we should have a committee that when there's no impeachment going on, agrees to a neutral set of rules that will take off the shelf the next time we have a process. Something like that doesn't seem to me outside the realm of possibility, and it seems like, that may be how you make progress on some of these issues.
I want to thank you both, thank our audience, thank the National Park Service.